Okay, good afternoon, everyone. My name is Silhouette. Thank you for tuning in again this afternoon. Just a brief recap of what we went through or what I presented yesterday. I presented a topic of stress management as well as conflict resolution. So if you want to listen more to that, just find my video. I did post it there. Today we are looking at a different topic. We'll be looking at labor issues. We look at workers' rights acts as well as laws surrounding the world of work. But before I go through or continue with my presentation, please just make sure to understand that here we are just doing revision sessions. It's not a scope for life orientation or what to expect, what to you will get on the 2nd of September, but it's type of questions that you'll encounter during the session. And then today I'll also cover past question paper on the topic that I'll be presenting on as to how to approach the question, how to answer, what to look for. I'll also go through that. Okay. So with that, without further ado, I'll start the presentation. Okay. So our presentation today, we're looking at labor issues, as I've already mentioned. And then we're looking specifically at workers' rights, laws, and acts. And then with that, let's go to the presentation. Okay, so what are workers' rights? Workers' rights are legal and human rights relating to labor relations between a worker and the employer. Okay, these rights are codified in national and international labor as well as employment law. In South Africa, workers and employers' rights are protected in the Labor Relations Act. And then worker rights are outlined in the Bill of Rights in Section 27 of the Constitution of South Africa. And then what are workers' rights? Um, the workers have a right to choose their own trade, meaning their profession they want to follow, or occupation or job. They have a right to choose that. And then they have a right to fair practices in the place that they work in. And then they have the right to join any trade union that will protect their interests. And then they have the right to be part of those programs that are organized by their trade unions. They also have a right to strike or protest if there is a condition that is not conducive or they're not happy about. It's important because we are talking about rights. It also comes with responsibility or obligation. So workers' obligation are as follows. They have to keep to the agreement of the job contract. Okay, the job contract will get to it later in this presentation. And then they must give the employer value for their money because they are earning a salary or a wage. So they must be productive during the working hours and not stay away from work or be absent from work without any valid reason. And then the employer's rights, they also have rights, are as follows. They have the right to join an employer's organization. An employer's organization is a collective organization such as manufacturers, retailers, and other employers that pay their employees a wage. Employers' organizations seek to coordinate behavior between their member companies in a matter of mutual interest, such as negotiation with trade unions or government bodies. In this case, the government of South Africa or the GNU. Okay, they also have a right to partake in programs and activities that are arranged by those employer organizations. And then they too also have obligations or responsibility that they must adhere to. The first one is to keep to the agreement of the job contract. You cannot change the conditions of employment without consulting or informing the employee. And then they cannot engage in unfair labor practices. They they have to arrange his business according to the labor law of the country. So they must adhere to all the regulations in terms of the laws that are guiding businesses in South Africa. And then they have to apply affirmative action. Affirmative action, we're going to talk about it a bit later also. Okay. And then they must also they must also ensure that there is equity. They must also apply the Equity Act in the workspace as well. Okay. And now we are talking about what to expect in the job contract. So conditions of service are as follows. The companies and jobs are not the same, so they will have different conditions in terms of service. Conditions of service include a number of hours that are expected for the employee to work or the worker to work, as well as amount of leave that the worker or the employee will get each year. All the conditions of service should be covered on your employment contract or the job contract. And then the second page of that, depending on your job or responsibility within the company, your conditions of service will also indicate items like disciplinary procedure. So if you are always late or you broke the rules of the company or the place that you're working at, disciplinary procedures or processes will be followed to discipline you. And then all the conditions of service are covered in the Basic Conditions of Employment Act, and each company should have a set of conditions of service in line with this law or this act. Okay, we move on. All the conditions of service are covered also in the Basic Condition of Employment. I think I'm repeating that. Oh, no, I'm not. And then the act will protect you and the employer from taking advantage of each other and practicing unfairness in the workplace. And then they are there to protect you. Should you also indicate, and you should, your conditions of services should also indicate the policies and procedure in case of grievance in the company. So if you're not happy about something, you are able to implement or follow the conditions of your service to that company or business. Okay, so to mitigate job reservations, segregations, and exploitations of workers, South Africa is ruled by four major acts. The first being the Labour Relations Act, followed by the Basic Conditions of Employment, and then the Employment Equity Act, as well as Skills Development Act. These acts are designed to protect the rights of workers as well as employers, and all of them will affect you directly when you start working or when you start looking for a job. The Labour Relations Act covers all the interactions between the employer and the employee. The Act applies to all employers, workers, trade unions, as well as employer organizations, the one that I already spoke about earlier. And then the government controls all labor relations. It makes sure that the constitutional rights of all employers and employees are adhered to. Now we're going to look at the Employment Equity Act. So what is it, or what is the purpose of it? The purpose of this act is to ensure equity is achieved and maintained in the workplace. It also promotes equal opportunity and fair treatment in the employment through eliminating unfair labor practices such as discrimination in the workplace. It also ensures that the implementation of affirmative action to redress is also applied to the different or designated groups that were affected in the past. So, excuse me. So, what does the law say about affirmative action? Affirmative action measures are intended to ensure that suitably qualified employees from designated groups, whether being black, white, colored, disabled, all have equal employment opportunities and are equitably represented in all occupational categories and levels of the workforce. And then other measures, they identify and eliminate barriers that affect designated groups. They also promote diversity as well as train the designated groups. It also it's also a preferred or a preferential treatment to ensure equal representation in the workplace. The reason for this in our context of South Africa is because I'm sure that you are aware that we once had a period of apartheid once upon a time where black people or African people were disadvantaged, they were marginalized, they were segregated, they were exploited. There are no opportunities of working in management or getting high paying jobs. So affirmative action seeks to redress that. And it's not only black people, African people that were affected, women as well as this what you call it, disabled people or people that are living with disabilities. They were also affected. Okay. Now we look at the Basic Conditions of Employment Act, also known as the BCEA. Okay, so who is this act for? It is for all the workers as well as the employers. It is for workers that work more than 24 hours in a month. A worker if a worker is a full-time worker, then this act protects that person. And then who is excluded? All members that volunteer or work for charity organizations, and then members of the National Defense Force, the National Intelligence Agency, as well as the South African Secret Services are not bound or are not protected by this act. And then we look at what is contained within the act. The first is working time. So a worker must not work more than 45 hours a week. And then if they are working for 5 days a week or less, they must work for 9 hours a day. And then if they're working for more than 5 days a week, and then they're going to have 8 hours a day in terms of their workplace. And then when it comes to overtime, workers must agree to work overtime. They are not to work more than 3 hours per overtime or 10 hours per week or per day, 3 hours per day of overtime and 10 hours of overtime per week. And then in terms of payment or remuneration, they must receive 1.5 times the usual pay or the normal pay. And then the employers must adhere and keep to that. And then workers that can also compress their work in terms of time. So they can work up to 12 hours a day and then they work less days per week. This you'll find mostly in medical or health field of careers. So nurses do that. They work 12-hour shifts and then they rest for 12 hours. They work 12-hour shifts and then they rest for 12. And then that's how it goes. And then when it comes to breaks or rest periods, a worker must have a meal break that is up to 60 minutes after 5 hours of work. And then this can be lowered to 30 minutes, but then there has to be an agreement between the employer and the employee. And then for employees that work only 6 hours, they may not have a meal break because of the hours that they are working. And then a worker must have rest for a continuous of 12 hours or a weekly rest after. And and then a weekly rest is 36 hours of continuous rest after work. And then when it comes to leave, we have different leaves. A worker can take 21 continuous days in terms of the annual leave, and then they get 1 day for every 17 days that they work, or they get 1 hour for every 17 hours that they work. And then the employer can only pay an employee for leave not taken once they leave the job. So if they resign or they retire, the employer will then give that employee the money for the leave days that they did not take while they were working. And then sick leave, a worker can take up to 6 weeks paid sick leave during a 36-day leave cycle. During the first 6 months of a worker, that they can take a paid leave for every 26 days that they work. And then an employer can ask for a medical certificate or proof if a worker or an employee is not at work. And then if it is not at work for 2 days in an 8-week period. And then when it comes to sick leave, I think I'm repeating that. And then maternity leave, when an employee is pregnant, they can take up to 4 continuous months of maternity leave. And then they can start from 4 weeks before the expected birth. And then a pregnant employee may not work for 6 weeks after the giving birth unless a doctor or a nurse or a midwife declares that worker or that employee to be fit for duty. And then when it comes to family responsibility leave, full-time workers who are employed for more than 4 months can take paid family responsibility when, one, they are expecting a birth in the family, or when there is a death of a spouse or a life partner, or an adopted parent, grandparent, child, adopted child, grandparent, sibling. And then employers are entitled to proof or evidence for such leave. So when you when you are coming back or reporting back from that responsibility leave, then you must provide proof for the employer. And then the principles of equity and redress. In South Africa, as I've mentioned before, we have a history of inequality as well as exploitation when it comes to labor practices. Previously, we were divided according to color, where black people, as I mentioned before, they were marginalized, as well as females and people that are living with disabilities. They were marginalized. They did not have those opportunities. Therefore, in terms of redressing, people that were previously disadvantaged in the past are to be promoted, or they are to be preferred. This speaks to affirmative action that we spoke about earlier. Okay. So now the question, what is the difference between an affirmative action and employment equity? Affirmative action deals with equal employment opportunities and equal representation in all occupation groups and levels in the workplace, while employment equity has to do with a number of workers from different groups in the workplace. Equity is achieved through affirmative action. And then work ethics. This is an important part, or this is an important question. It does appear quite a lot in the LOCAT when I look at the past exam question paper. Okay, so work ethics deals with the worker's attitude towards his or her employer. Okay, you can compare it with your attitude to your work and your responsibility towards your schoolwork. It involves attitudes, behavior, respect, honesty, accountability, communication, as well as interaction with others. It can be compared with effort you take to study, or how you respect your teachers and fellow students or learners and make your school a better place. A good work ethic refers to a positive attitude and commitment to your work, or in your case, to your schoolwork. And then work ethic demonstrates the decision that you make about what is right and acceptable against what is wrong and unacceptable. They come from within the person and give others a pictures of your value, cultural upbringing, and then cultural background as well. People with good work ethics are likely to keep their jobs as well as make a success of their work. They will also benefit from their good work ethic by coming in line for a promotion or advancement in terms of your career. So the skills of having a good work ethic are referred to soft skills. You identify this, the willingness to work and be taught by a senior person or a supervisor, the ability to get along with other employees or other workers in the workplace, the behavior and attitude of the worker towards the company, and being on time and being at work without taking leave or sick leave unnecessarily without any proper reason. A good work ethic is the most important skill in keeping a good job. Okay. Um, Good work will start the moment you apply for a job. How so? It will show through your CV. If your CV is neat, complete, and organized, this will show a good work ethic and your potential employer or the potential person that you'll be working for. When you start a new job, the first thing your supervisor will notice is the time that you arrive for work and the time that you leave your work or when you go home. It will also show in the way you dress for work, or volunteer for new tasks in the company, or cooperate with other employees and contribute new ideas within the company or the workplace. You will have an attitude of what you can offer the company instead of what you can, or instead of what the company can offer you. Okay. And then we are almost at the end. We're talking about societal expectation. Societal expectation refers to what the society or the people in the community expect of other people sharing the same community as them. It is about how people expect other people to behave, how to treat them, how to interact with them. It is all can also be compared to basic human rights in our constitution. Rights like how you treat others in terms of respect, how safe you are, how you are treated with dignity, and then how to approach people by not judging them unfairly. It also refers to our environment in terms of keeping it clean, neat, and safe. And then this is in protection of the future that we have. And then we also enter the world of work with people in the workplace. And then those people also have certain expectations of you, the way they behave and how you behave as well. So each society and community will have its own expectations based on the culture, values, as well as religious expectations or experience that they have. So when you apply for a job, it's important that you make sure that your personal values as well as your personal belief fit with the expectations of the workplace that you're going to be applying to. And with that, we've reached the end of this presentation. So if you have any questions or comments regarding this presentation, please feel free to put it in the comment section and then I'll reply to it. So before we close the section, I just want to go through the EloCat example pertaining this topic. So I will project now a potential or a question that was asked in previous years. The question is around the topic that we are discussing, around worker rights, laws, as well as acts. Okay, let me close this one and open it. But before we do that, I want to speak about mark allocation. I know in the first part of this series, I did break down mark allocation, but I feel that it's important. So I will go and break it some more or break it again. Okay. So mark allocation, there's two things that you need to look at in terms of the mark allocation. Always the mark allocation will be within brackets. So whatever is happening within those brackets or in between those brackets is telling you how to approach and how to answer the question, how comprehensive you have to go, and then what you need to do as well. Okay. So the first number within the brackets in this example that is projected now, the first bracket is 2 times 1. That simply means that the first number 2 speaks to the facts, the statements, or the opinions that you must give, and then each fact is worth a mark each. And or the second example is 3 times 2. It means here you must give 3 facts, and then each fact accounts for 2 marks. Okay, that is just explaining, the second part is explaining what I just said. So the second number relates to the scope or the depth or how comprehensive you have to answer the question. And then in this example, there's a 1 plus 2. The 1 plus 2 relates to a 2 instruction question. So the question is one question, but that question is broken into 2. So an example that I gave in the first video would be give what is the definition of communication, and then the second part would be give 2 examples of positive or give 2 examples of a negative communication. So you'll get 1 mark for the definition or the meaning of communication, and then plus the 2 marks for the positive or the negative examples that you will give. And then the next example, it's 2 times 3. The 2 relates to the number of facts, opinions, and statements that you give. And then the 3 relates to the depth or how comprehensive you have to answer the question. So the first mark goes for the fact, statement, or opinion. The second mark, you qualify. And then the third mark goes to the outcome or the result. And then this example that I just predicted now is mostly found in section C. So section C is quite comprehensive when it comes to marks. Each question carries a quite a significant amount of marks. So in this example, it's 2 times 4, which means that you have to give 2 facts, and each fact is 4 marks each. Okay. The first mark is for the fact, opinion, or statement. The second mark is for elaboration. The third mark is for qualifying. And then the fourth mark goes to the result or the outcome of whatever fact that you are discussing. Or alternatively, the first mark goes to the fact, statement, or opinion, and then you qualify it for the second mark. The third mark, again, is another fact, statement, or opinion, and then you qualify it for the fourth mark. Okay, so that is it when it comes to mark allocation. Now, I'm just going to project a past question that we found, I think it was 2022, if it was not last year. The question is around workers' rights, laws, as well as acts. Let me project that now. Okay. 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 So the first question that you'll get is define the term job contract. Here you are defining. So here it means that you have to, the mark allocation is 1 times 2. In this case, you give the what you call the meaning, because you are defining, and then the second marker will go to the example. So the meaning, you'll get an example. For example, that will be the second mark. Okay. Or qualifying rather. So this is how you answer. This is how we normally we mark when we mark as markers for the paper. So you'll see there it says mark should be awarded as follows: 2 times mark. You'll see there in brackets the U with the what do you call this? The 2 dots on top speaks to the mark. So 2 marks. That's a tick for a well-explained response. So in response to this question, what is a job contract? A job contract is a written agreement between an employer and a worker, 1 mark. It offers guidelines as well as expectations of the job. The mark goes there. It is also an example. Okay. And then an alternative response will be it's a binding document between an employer and a worker. An example, It specifies and details the worker's duty or the employee's duties, responsibilities, as well as obligations. Another variation or another answer, it is a signed agreement between an employer and a worker, and it is bound by law. Okay, as we said that the government oversees all work relations. Another response would be it's a legal written guideline, which is true. And then what does it do? It aims to promote good working relationships between the employer as well as the employee. So you see in this example is that there's a mark for the statement, fact, or opinion, and then you qualify it by giving an example or elaborating more on the fact that you have given. In our next example, it says, explain why the BCEA, or the Basic Condition of Employment Act of 1997, protects underage children from working in a formal work environment. Here, it's one fact, and then it accounts for 2 marks each. Okay, so it means there's a fact, a statement or opinion that you give, and then you qualify it for the second mark. And then potential responses here, when we're relating, we're explaining, the responsibility of a formal job may add stress to a child's life. That is why they need to be protected, because they may not be emotionally ready to deal with failures and challenges of tasks in the workplace. Now you have qualified it. And then alternatively, a formal working environment may expose underage children to inappropriate situations, unlawful activities, dangerous working environments, as well as people. That is a statement, fact, or opinion. And then now you qualify it, which may not be able, to cope or deal with, and may endanger their health or their safety. That is the qualification. And then an early engagement in the demands of the adult life or the adult world. And that's why we are protecting them. They are still too young. You qualify it because they may lead the children to not knowing how to deal with the effects of their childhood ending soon. Or underage children may be unskilled in a specific job. That's why you need to protect them, and therefore it may be too labor intensive for their physical capacity. So they may not be able to physically do whatever work demand that is required of them. So those are just examples. I just want to reiterate now that these are past question papers. This is not the scope of the LOCAT that you'll be writing on the 2nd of September. Okay. And next question, how could an employer assist a young worker to minimize the consequences of misreading or not reading a job contract? So here, I just advise, please always read something that you're going to you bind yourself to. So anything that you will sign, always make time to read. It's very important, okay? So anyway, the question is, how could an employer assist a young worker that does not read or misread their job contract? Possible responses there. The employer could ensure that the lawyers drawing up these contracts simplify the language. That's what they can do to minimize the consequences. Number two, secondly, to qualify, I didn't explain the mark allocation. It's 2 times 2, which is 2 facts, statements or opinions, and then each is with 2 marks, 2 marks, and then you qualify it for the second mark. Okay, so the qualify so that the worker who are not fluent readers may also understand what is written there. Okay. And then another possible response, employers could allow for workers to read their contracts at home so that they can create a favorable environment that they are comfortable in, so they're able to read it without pressure before they sign. That will be the second or the qualifier. And then employers could also have translators, interpreters available to explain the contract using that employee's language so they may understand. And then to qualify it, since they use the language to qualify it, it will be more easier or less difficult to understand what is written there. Okay. So here it's important to use your own language. Just explain it how you understand it. That is will help you. Okay. And then the next question is assess two advantages for an employer who provide workers with a job contract. And then the mark allocation is always important. Look at that first. It's 2 times 2, which means 2 responses, and then with 2 marks each. First mark, fact, opinion, or statement. The second mark is a qualifier. So the response is in terms of advantages. It may minimize incidents of non-compliance by workers, and an employer may also have to deal with daily, and then qualify it, and this may send a clear message to workers of the legal rights of the employer, okay, in case of disputes. So I'm not going to read through that. You can just pause the screen to see in terms of breakdown. But the first point helps the employee to establish, that's the first, and thereby reducing possible risk. That's the qualifier, the second mark. The third point is to protect the business. That's the first mark. And then the qualifier, thereby reducing the possibility of legal claims against the employer. That's the qualifier. And then the last question is examine why it is important for the worker to review a job contract. Okay. In each answer, also indicate how reviewing it may benefit the employer. I mean the worker. I beg your pardon. The pardon there. The mark allocation is 2 times 3, which means that it's 2 facts, 2 responses, and then each response is 3 marks each. The first mark, fact, statement, or opinion. The second mark, qualify, and then the third mark, the outcome or the result. Okay, I'm just gonna go through one example there. So possible answers could be: you may realize that your job description has changed. You've gained new skills. That is a benefit of reviewing. That's number one. That's the statement, opinion, or fact. And then the qualifier, you may not be, excuse me, and you are not being compensated accordingly. That is a qualifier. And then the outcome, which may then enable you to renegotiate your salary. That would be the outcome or the result thereof of reading or going through or reviewing the contract. Another response, the working conditions of the worker may not need to improve. That's why it's important. And then to qualify it, since it may not be in accordance with the applicable labor law. That's the qualifier. And if the worker would ensure that these amendments are effected in the contract, they may legally be entitled to more conducive working environment. That is the outcome or the result. And then the last response, a company may upgrade equipment to meet the 21st century technological advances. That is the statement, opinion or effect, depending whichever. And then to qualify it, and as a worker, you may need to be upskilled. That would be the qualifier. And then the outcome, which may then ensure that you hold the employer accountable for the relevant training that you've acquired to be more efficient in the job that you are doing. And that is it. Just want to touch again here. This is an example, it's not a scope. So if you do want past question papers that are more comprehensive, I will, yes, I'll link it in the question paper in the comment section below. I'll create a link for that. Yeah, with that, we've reached the end of this presentation for today. Thank you for watching. Again, if you have any comments, questions that you would like to ask me, please feel free to do so. Tomorrow, we'll be looking at unemployment and entrepreneurship. Um, I'm not seeing any questions thus far. The only comment I see is from Sipesihle saying, "Thank you, sir." You're welcome, my good sir. I don't see any other comments. And with that, thank you for spending time with me, for indulging me. I'm hoping that these will assist you um, as you prepare for your LOCAT exam. Okay, I will post this so we'll have access to it. And then with that, calling it a day since there are no questions. Yeah, thank you again. I'll see you tomorrow.